Hello everyone and welcome to The Sydneyist, a weekly conversation about the city we love. Our motto here at The Sydneyist is much curiosity, a smidgen of cheek and definitely no whinging. I'm Elizabeth Farrelly and we're broadcasting from the Alan Slate studio in the basement at Eastside Radio on 89.7 FM or streaming on eastsidefm.org. Tonight we're talking laws, specifically protest laws. It's National Road Safety Week and there's been much talk about why we need to reallocate street space to give less priority to cars and more to pedestrians. But streets are not simply corridors, they're also places, public living rooms, if you will, for assembly and often for dissent. That is to say, protest. My guest this evening is the remarkable professor, I want to say professor of protest, but professor of Emeritus Professor of Law at Sydney Uni, Simon Rice. OAM, is that right?
Yes, you had a bit. Yep.
I dug that out. Yes, you're very modest about it. Welcome, Simon.
Thanks,
Thank you for being here.
Great to be here.
Professor Simon Rice describes himself very modestly, I think, as, quote, lawyer, advocate, consultant and academic who works and researches extensively in anti-discrimination law, human rights law, access to justice, law reform and legal education, Aboriginal land rights and organisational strategy. He's held too many chairs and championed too many important causes to name here, and has the distinction as well of having successfully sued the New South Wales government for wrongful arrest under its protest laws during a student protest, in which I think he was not actually involved, but a bystander on campus. Is that right, Simon?
Yes, that's right. I was observing.
Yeah. Observing and showing the students this is what a protest looks like. So tell us, if you would, just how that came about.
I teach a course called Law Reform, which is effectively a course in social action, opening students up to the way the world works beyond law. And part of that is talking about social movements and how you bring about social change, and part of that is protest. So there is law on protest. I told the student about that, and there was a protest happening on campus. So I said, let's go and watch. So we did. I walked along beside the protest. I was closer to the police than I was to the protest, wandering around campus while the students were engaged in what, to be honest, were fairly lame chants of what do we want, when do we want it, sort of stuff, about fees. And then the students, the protesters all got to a bottleneck on Parramatta Road and a bit of an impasse. I was watching all this, and suddenly the police just moved in on a signal, and I saw the police behaving appallingly, grabbing hold of people, throwing them to the ground, tearing things out of their hands. So as a bystander, but as a lawyer and a citizen, I challenged them. I mean, I simply said, why are you doing that? And they wouldn't answer me. I said it again, why are you doing that? And then I was kicked to the ground and placed under arrest for resisting arrest. So, yes, that's how it came about, which caused some... gave me some notoriety among the students for having got that close to
huge
what I was teaching. Yes.
Yes. Demonstration of how it's done. Yes. So, and then just run us through, if you would, what happened next.
Well, to be fair, the context was it was during COVID times.
Yes.
So it was it wasn't an authorised protest, which doesn't mean it's illegal. There's no such thing as illegal protest, but it hadn't been formally authorised. So the police have discretion to manage that within bounds of what they think is permissible, and they decided that it was not permissible under the COVID laws. Now, they'd watched it for half an hour without doing anything, so why it suddenly became impermissible has never been explained. So it was in that context that they moved in and charged me with a COVID offence of being part of an unauthorised COVID gathering.
Although you weren't actually part of it.
No, I wasn't, no. So, I had a number of grounds for defending it. I pleaded not guilty. I went to the Downing Centre and was set down for a hearing, but then the police prosecutor withdrew the charge, and I suspect that they withdrew the charge when they saw for the first time the body-worn video footage, which showed the conduct of the police. I had seen all the body-worn footage, and it's not the sort of thing that the police would have wanted in open court. I suspect. So it never made it into court, and I can't do anything with it because it's not public. But the charge was dropped. So then I was left with...
So you don't have the choice at that point to pursue it through court?
No, I mean, that was their charge against me, which I was going to use as an opportunity to hold them to account, but they took that from me. I complained to the police, but there's a threshold for complaining about police conduct, which has to be serious misconduct. And I was just complaining about the bad way they did their normal job. So the Law Enforcement Conduct Committee wouldn't look at that. The police investigated themselves and said everything was okay. So again, I had no...
Good heavens.
Yes. And all I could do then was sue them, which I did for assault and battery and false imprisonment.
Yeah. It's funny. I mean, we've been laughing about it, but it's not really funny, is it?
No, it's a very small indication of what happens literally all day, every day. And I was in a privileged position as an accused person.
That's right.
This happens to migrants, Aboriginal kids,
all kinds of people,
all the time who don't have the resources to do something about it. It's a serious question of power, state power. Yes.
So you've said in a lecture that in New South Wales, the law of protest is actually a law against protest, which means essentially, as I understand it, that we in New South Wales do not have a right of peaceful protest. Is that right?
No. What I meant to say then was we start from the position of, yes, you have an entitlement to protest unless there's a law against it.
Yes.
So the laws in New South Wales don't enable protest. That's a fundamental common law right.
Yes.
What they do is constrain the extent to which you can exercise that right. So you start from, you can do what you like unless there's a law against it. There happen to be quite a few laws against it.
Quite a few laws against it, yes. And so I'm just curious about the question of police discretion, because that means that in authorising a protest, the police come into play and they have to exercise their judgment as whether it does or doesn't breach any of those many laws. Is that right? So does that allow room for them to have a view of the content of the protest?
Yes. So under the Summary Offences Act in New South Wales, you can apply for permission for a protest and the police can give you permission, but there are no prescribed criteria for that.
Yes.
The judges have developed a bit of a checklist of things they think about, and the police then anticipate what the judges would say and do that. And the purpose of the protest is one of those considerations. It's hard to see why that should be the case, because it's a subjective value. They'll allow some things to be protested and others, but as I say, it's not prescribed. It's just a consideration. So what you're protesting about could be a factor they consider.
And so if you were having a protest, say, against police powers, the police could just decide that was not legitimate and wouldn't have to justify their...
Well, they would, because you would take that to the court. You would challenge that in court.
But you would have to challenge it in order to get permission.
Yes, that's right.
And a lot of people wouldn't or couldn't.
Probably not.
Because that would cost money? Would it?
No.
Like if, say, it was, I don't know, Greenpeace or someone...
Yes, you get pro bono assistance. It's reasonably straightforward to take a police refusal to the court. And the judges of the Supreme Court are quite familiar with this. And organisations like, say, Black Lives Matter, BLM, know the ropes and they can go in there and argue their case.
So that is a kind of safeguard.
Yes. And the judges will bring their views on the legitimacy of the protest to it. They tend to be more liberal, but they will still weigh up what they think is permissible.
Yes. So when you look at, obviously we're interested in Sydney and Sydney's culture and history and cultural history, and when you look at that, it's fairly clear that an awful lot of the things that we've gained, including land rights and feminism and a few other useful things like that, have come through protest. So how would you encapsulate why protest matters?
Political theory will tell you that it's about public expression of will. It's a democratic process. It's a measure of our democracy that we're permitted to protest. It's a liberal value. So that's one way of thinking of it. It is an expression of liberal values, and so constraining it starts to raise questions about the extent to which you're retreating from those liberal values. That's one way of doing it. Another is, so that's taking part of the democratic process. You could also view protest as a public forum in itself. you referred to roads before. I mean, you know the history of roads. There were roads before there were cars.
Yes, absolutely.
And roads were go right back to the commons. It's places where people gathered.
There are places.
Precisely. So protest is a way in which people get together and share views and express themselves. Whether or not that's part of the democratic process, I think you can say that's their importance. And yes, they are tools of political expression. They move things along. They bring to the surface stuff that doesn't get expressed otherwise. You can't rely on representative democracy to say everything for you. Sometimes you have to say it yourself.
Yeah, absolutely. And the history of dissent, I mean, even things like thalidomide, you know, the necessity for a dissenting view, which is often regarded as being minority and rather stupid at the time, and derided by authority, has done very good things, in historically speaking. But so does it mean, do you think, that we should have a Bill of Rights in New South Wales or in Australia?
One of the odd things about Australia is that we're just about alone. We are alone in the Western developed world in not having a statutory guarantee of rights. And one of the arguments made in defence of that position is, everything's okay. What's your problem? Look around you. You've got freedoms. What do you need a Human Rights Act for? And there's something in that. We do have admirably robust institutions that largely protect us. We don't have a corrupt judiciary, by and large. We don't have a corrupt political system. There are measures of accountability. So it's easy to say everything's okay.
There are a few problems with whistleblowers and
yes, so that's what I say. That's what I was going to say, that beyond the obvious, we have institutions we can rely on, there's a great deal that goes on that isn't public and that's not accountable.
Yes.
Significantly, the level below institutions, which is administration, the way in which services are delivered, in which discretions are carried out by not just by police, but by housing officers, by Centrelink officers. There's a whole range of things that affect our lives that actually aren't obviously and accessibly regulated. A Human Rights Act would dig into that, would keep people accountable. That's what we see happening in...
So, I mean, I may be alone in thinking that the Australian Constitution is one of the most boring documents ever written.
No, that's consensus.
Good. But, I fantasize about a Bill of Rights that has... that is simple and clear and has beautiful language in the way that, the American bits of the American founding documents do. So if say you imagined a Bill of Rights that was, I don't know, one page, let's say.
Well, funny you mention that. Can I just say, Elizabeth, this isn't to correct you, but just to make a point. The term Bill of Rights is commonly used, but I think it always invokes the idea of the USA. And that's a problem because we can't talk about something. That's a very idiosyncratic, historically odd document, the US Bill of Rights.
Okay.
Elsewhere, I mean, the campaign in Australia at the moment for a national Human Rights Act is called that, for a National Human Rights Act or a Human Rights Law. Like in New Zealand and the UK, they have a Human Rights Act. In Canada, they have a Charter of Human Rights. And that's probably a better term just so that people...
don't think
such
America.
As Mr. Carr used to do, immediately start beating over the head with American examples. It's just not going to happen.
Yes.
So I actually, my contribution to the National Human Rights Act campaign, which has promulgated a very long, complex, tedious Human Rights Act, was to give them a one-pager. I have written a one-page Human Rights Act.
I like it.
And it's possible.
Do you happen to have it here in your pocket?
I didn't bring it with me, but I seem to remember it had about 12 numbered paragraphs.
Yep.
And now, yes, lawyers will get hold of that and you'll start to parse it. But as a starting point, to say to people, this is what we're talking about, the one-pager is a must.
You really want it just in principle.
Yes.
We have a right to free speech.
Precisely.
We have a right to housing or something. Yes.
The Universal Declaration of Human Rights is actually a pretty good start. That's close to a one-pager, and you look at it and you recognise everything there that you think is good.
And so to have that, would we have to have a referendum or something?
No, if they could just pass an act. So the Racial Discrimination Act is just an act, but it's an act that is of such important status that it's unimaginable that it would be repealed.
Yes.
That's the risk of passing just an act, that the next government could repeal it.
Yes, or amend it.
Yeah, or amend it. So the Victorian Liberal government, when it was elected some years ago, was elected on a platform to repeal the Victorian Charter of Human Rights. Once they were in office, they didn't have the courage to do that. You can't take that away. So passing, it would be a mere act, but it would be a seriously good act.
Yeah, yes. That sounds like a very good moment to have a little bit of music.
Child, and don't cry. Your folks might understand you by and by. Just move on up toward your destination. Though you may find from time to time complications. Just move on up for peace you'll find into the steeple of beautiful people where there's only one kind. So hush now, child, and don't cry. Your folks might understand you by and by. Move on.
That, of course, was Curtis Mayfield with Move On Up, which I'm sure you know. I'm Elizabeth Farrelly. We're here at Eastside Radio in the Ellen Slate studio, deep in the dungeon of Eastside. And I'm here with Professor Simon Rice, and we're talking about the laws of protest in New South Wales in particular. I want to look now, Simon, at the trajectory of protest legislation in New South Wales and in Sydney and how that's changed, because it sounds to me as though it's always been perhaps a bit draconian, but it's getting more so. Is that right?
There has certainly been a flurry lately. It's funny, somebody who went to look for it wouldn't find it. If you did a search of protest law, where is it? It's actually hidden away in other acts. So the Roads Act is one place that constrains your ability to be on roads. The Crimes Act, unsurprisingly, does it. Yeah. Police powers under the... there's an act called the LEPRA Act, the Law Enforcement Police Powers Act. So it's hard to find. It's all these little bits scattered around which, taken together, constrain what you can do.
Yes.
They've always been there. There's always been concerns about protests blocking roads and causing disruption. But yes, it has really ramped up basically in the 21st century, in the last 15, 20 years. People might remember when the protesters painted "No War" in red paint on the Opera House sails.
Yes, we do remember that.
Yeah, okay, so that was emphatic, harmless.
Yes, purposeful, attention-getting.
Precisely, and sort of fun. People thought, yay.
Yeah.
Now, that's now covered by amendments that prevent you climbing on public buildings. And so,
and what would happen to those people now?
Well, they'd be subject to criminal proceedings, a bit like Coco Violet. Maybe a harsh magistrate would lock them up, then on appeal. So there are stages to this. First is there a law against it? Then is how is law enforced? Are there charges? And then what do the courts do with it? And the point at which you probably take most comfort is in how the courts deal with it.
But that's sort of discretionary.
It is, but there's according to precedent.
Yes.
I mean, and so first offence, all that sort of thing, how you deal with criminal.
Yeah.
But back to your question, the laws have been increasingly restricting what you can do under protest. Yes.
Are you able to summarise the things that you can no longer do, or the ways in which that's become more restrictive?
One way of thinking about it is, where do protests happen? Where are protests effective? And you say, well, in public, take the Opera House, on streets, outside Parliament, and increasingly we've seen the environmental protesters doing it in ways that impede people, so on footpaths and bridges and so on. So if you think, where did that happen? Then you say, I wonder if there's a law against that. And yes.
Yes.
So what the laws prevent you doing is climbing on buildings, blocking roads, blocking bridges.
Any building, like...
Yes, yeah. And then there's a special provision for, and I've forgotten the word, but it's about infrastructure. So it was designed to stop people blocking the Botany Bay ports, for example.
Yes.
So the laws are responding to where people are taking their protest and saying, no, can't do that, can't do that, can't do that. And there's now, if you find it in all the pieces of legislation, there's a long list of things you can't do anymore.
Yeah. And is that reasonable?
I think what's unreasonable is this preemptive legislation against a protest.
Yes.
Simply because it's happening somewhere. The legislation doesn't say whether or not it's a loud protest or an obstructive protest or a warranted protest. It's happening on a bridge, you can't do it.
And so even, in that case, even the police can't give you permission to do it?
No, they can't. They certainly can't give you permission to do it.
Yeah.
Now, the police always have a discretion about whether or not to pursue somebody for an apparent offence.
Yeah.
They can let things go to a point where they say, look, just let them be on the bridge for a while and then they go away.
Yeah.
Or they could decide not to. Yeah. So police discretion comes into this all the time, and that's very hard to...
You can't anticipate. Yes.
You absolutely can't.
So you might be arrested and fined $20,000, or you might be fined.
Yep. Yes. And if
it's very uncomfortable.
If you've got a shipping company whose business is being impeded and they can't unload, then the police will be under significant pressure to do something about it. If you've got a bridge on a Sunday afternoon that's being blocked for a short while with an unauthorised protest, they might just let you go. So it is very uncertain. It's hard to plan.
So, and what would be a better way of framing that legislation, do you think? Is there a way of doing it that's not by kind of incremental prohibition like that it's just...
I think there is, and I won't labour the human rights point, but most of the Western world operates with human rights laws that engage in this process of weighing things up.
Yes.
Now, we don't weigh this up. We just have a law that says you can't do it. If instead we had a process where it said, you want to do that? Let's weigh up your right to do that against other people's right to free access or commerce of business. Is there a better way you can do this? Could you do it in a different place, a different time? Can we...
Yeah.
And then give permission. Under the Summary Offences Act, we don't know what the criteria are. So yes, I think it could be done better if we had a weighing up of competing rights and the police were told, you will assess the purpose for the protest and the way which operates against any countervailing considerations, and you'll make a decision accordingly. There's always going to be a judgment, but we could have a much more guided judgment than we do.
Of course, I suppose I mean, I've never organised a protest, but I suppose...
I'm surprised. You'd probably be inadvertently responsible for something.
Yes. Have participated in one or two. Possibly should have. Anyway, there's time yet. But I imagine if you are doing that, then, some level of disruption is part of what
That's the point of protest.
Yes. You need attention.
Yes, so, you need attention.
Yes, so it's like a strike in a way.
So again, it's judgment. The no war paint on the Opera House sails gathered attention and didn't prevent anyone going about their business. Extinction Rebellion blocking tunnels in peak hour gained attention and was seriously disruptive.
Yes.
Now, there's no avoiding the fact that a judgment has to be made.
Yeah.
And some people, it doesn't matter what laws there are, they're going to do it.
Yeah.
So that's fine. That's their call if they make a choice. But at the moment, I think we have people like the knitting nannies who really...
I love the knitting nannies. Yeah.
Are they doing anyone any harm? Yeah. Yes, they may be blocking a bulldozer going, okay, well, work that out. But to simply pass a law that says you will not block a road by knitting is
yes.
irrationally preemptive, I think.
Yes. Interesting, isn't it? So does this increasing restrictiveness, is this just us, or is this like an international trend?
No, it's certainly, Australia-wide trend. Tasmania, Queensland.
So Queensland has a Bill of Rights or some kind
They
of...
have a Human Rights Act.
Rights Act, yes.
Which does require this weighing up of competing considerations.
But they're still becoming more restrictive.
Yes, they're still passing...
Yeah.
So one of the odd things about human rights laws in Victoria, ACT and Queensland, which is where they are, is that they actually don't override other laws. So the government can pass a law and openly declare, yes, this law breaches human rights, but we've decided to do that. So it's not an overriding law.
Okay.
Around the world, I actually don't know whether laws have changed, but protests are certainly becoming more aggressive, if you like, apparently around environmental issues. No, let me withdraw that. I don't know whether they're becoming more aggressive. The response to them is certainly becoming harsher.
Yes.
So people are being constrained in their rights to protest much more now than they were.
Yeah.
Whether that's because the protests are different, I don't know. But a general move towards, I hesitate to say autocracy, but, stronger use of state powers, largely supported. I mean, state powers are being used more aggressively in the name of community safety.
Yes.
Family values, a whole range of labels that allow the state to behave much more aggressively now than it used to.
Yes. It's interesting, isn't it? And I think, and I don't know the extent to which these things go together, but to me there seems to be an interesting parallel with the idea of free speech and the question of whether... I mean, because dissent and spoken dissent and protest are obviously similar in some ways. After the Charlottesville attack in 2017, Carol Christ, who was the Chancellor of UC Berkeley, said she advised extreme scepticism about the right of any authority to determine which opinions are noxious or abhorrent. And she said the best way to respond to hate speech is with more speech. So, and I'm curious, so that obviously runs in the face of quite a lot of current thinking about hate speech and vilification and how those things should be either censored or, mitigated by law. And it also plays to the question of cancel culture and what role that has in this kind of increasing...
Just a quick response from the time I spent a long time defending 18C, our racial vilification law, because I understand the American position of more speech. The people who are subject to vilification laws are disempowered. They don't have access to the platforms of the people who are abusing them. So I do think you've got to be more nuanced in understanding speech when you've got to work out whose speech is it that you are talking about.
That's a very good point. So if you had 20 seconds to say what you would change if you were the King of New South Wales in this regard?
There's no changing the history of the police in New South Wales.
That's a shame.
But I would, it's not a direct response apparently, but I would increase the police accountability. I would reinstate the Ombudsman's role. I would reinstate an independent oversight of the police, because I think that a lot of what we're talking about comes down to decisions they make regardless of what the legislation says. And then I would have legislation which was much more flexible and less preemptive in its terms.
Yeah, okay. That sounds like a topic for another conversation at another time. But we have to stop there, I'm afraid, folks. It's a wrap, as they say. I've been talking with Professor Simon Rice, OAM, about New South Wales law of protest. Handing now to Yone on the Vinyl Frontier. Thank you for joining us.